Okay, well, I guess we'll get started. Hi, everybody. My name is, for those of you who don't know me, my name is Will Tiao. I am the director of the commercial division at the Collective Realty, who's hosting our meetup today. I'm also the owner and broker of Tiao Properties, which is a property management firm that I run with my wife and partner Diana, who's on the call as well. And we manage several hundred units throughout the Los Angeles area. And we're also investors ourselves, landlords ourselves. We've also been tenants ourselves. So we kind of have been on both sides of the coin when it comes to multifamily and the multifamily industry. Welcome to the Los Angeles Multifamily Networking Investor Group. We have been running this group now for about 4 years, and we've cracked the 1,100 member mark in our meetup. And I've seen several of you before. Welcome back. And for those of you who this is your first time here, welcome. This is a group for us to share information on what's going on in the multifamily market in Los Angeles. And we always try to invite interesting guest speakers who can speak specifically on issues that are happening in the multifamily industry. Obviously, today's topic is a hot one for everybody, and that is landlord tenant regulations in the COVID era. For those of you who have been at our meetings before, you know that we have covered this topic before, but because it is a ever-changing area of the law and of regulations, and for those of us on the ground, it's a constant dance of knowing what's happening. And so I know a number of you on the call own property, are landlords, some of you may be tenants as well. So we've gotten tons of questions about what is going on, which is why we invited our guest speaker, Eileen Kendall, to come speak today, because she is an expert in this area, and something that we're going to get into momentarily. When we were meeting in person, one of the things we like to do was to kind of have everybody introduce themselves and talk about why they're here. We have a really we still have more people coming in as we're talking. we're up to 26 at this time. And the reason we did it the way we're doing it now is because we wanted to have there be a little bit more interaction. Before, we had just been doing, just having our speaker and ourselves be the host and have people type in their questions. But we wanted to try to be a little bit more interactive and kind of bring a little bit back the feeling that we had when we were all live together in a room, which is now 11 months ago. We're coming upon a year, right, since the last time we actually met as a group. Our very last session was February 2020 when we met together at the Collective Realty. I remember us canceling that March meeting because it was right during that weekend when everything just shut down. What I always like to start off with, of course, is what is going on right now in the market. And probably the biggest question I get there's two questions that I always get, right? One is as a property manager and one is as a broker. The question that I get, the number one question I get as a property manager, how is your collection rate? What type of delinquencies are you seeing? And I would say for us, I will say first and foremost, when I talk to property managers across the board, most of us agree that despite the pandemic, most of us are collecting the vast majority of the rent. And when I say the vast majority, I'm talking 90% or above. Now, I think that surprises a lot of people, especially given that we have multiple eviction moratoriums, which Eileen will get into. But we obviously have a federal eviction moratorium, we have a state eviction moratorium, we have a county one, and depending on your jurisdiction, you may have a local one as well. So that's 4 different eviction moratoriums. And I think, like I said, the hardest part is just knowing which one applies, if any or all, to any particular situation. But overall, collection rates have actually been quite good. I would say they're over 90%. In our case specifically, we're up to about 97, 98% collections. So that means we're almost at pre-COVID levels in terms of collections. Now, I know that surprises a lot of people, right? Because people are like, wow, like, you know, and the fact is that obviously we are in a new world. A lot of people have, I think, adapted to what's going on. The ones, you know, and obviously this whole pandemic recession has affected people differently. So at the beginning, those numbers were higher for us, right? We were closer to like 8 to 10%, you know, non-collection rate. And I think that for some property management companies, that's still the case. It's still in that range. We've gotten it down. I think a lot of it has had to do with the fact that we have worked very assiduously with both our tenants and our landlords to educate them on what everyone's rights are, which is very important, which is why we're having this discussion today. And in a lot of cases, we have found for our tenants that some of them have chosen to vacate their units because they would rather vacate than to continue to accumulate debt. And so once again, this is about education, not harassment, which we will get into. I'm sure Eileen, Kendall will be getting into. But the key is education, on both sides, for both the tenants and the landlords, and to be continually updated on what's happening with regards to landlord-tenant relations and regulations. So I think it's really great that you all are here today. It's also why, frankly, our phones have not stopped ringing because a lot of people, I think, have realized that they need professional support, particularly now, even if they own just a few units. You know, people are realizing that with all the changing regulations, they can be a little bit over their heads if they're not aware of what's going on. They have a day job and kids at home and all those things. So that's something for all of you to consider. That's the first question I get is what's your collection rate and what's your delinquency rate? The second question I get also on the management front is where are rental rates? And I would definitely say that I don't think there's any doubt about this. Rent rates have gone down in the city of Los Angeles, but it really depends on the type of property that you own. I will give you an example. In real estate, we tend to talk about different types of properties, Class A being luxury, Class B being below luxury, kind of not so nice, but not quite there. Class C being, frankly, the vast majority of buildings in Los Angeles, which is kind of your middle class, working class buildings. We have found that Class A properties, the luxury properties, are in real trouble. We manage a Class A condo in downtown Los Angeles. We put that on the market just regularly. We got no hits. We put out 1 month free, no hits. We put 2 months free. We started to get a few hits. When we offer 3 months free, okay, 3 months, that's 1/4 of your income for the year. We finally got someone. So that shows you the type of, the type of discount you're going to have to give if you have a luxury apartment that you're trying to rent. B class, I would say we've seen reductions anywhere from 5 to 15%. And C class, interestingly enough, we have seen very little reduction, meaning kind of your working class workforce housing. We have seen very little, like maybe a couple weeks rent concession, maybe $50 off. But these are properties that were already priced fairly low in the first place. And I think, once again, that surprises a lot of people. People are not expecting that. So that's something to consider. Now, those are the two questions I get on the management side. What does that mean on the sales side, right? Because a lot of people are like, well, if rent rates are going down, right? And this is not in question, right? People are leaving Los Angeles. People are leaving California. People are moving back home. People, the demographics are shifting. I mean, vacancy rates are up. All of this was non-existent a year ago, okay? So this has really changed things, right? So everybody assumes that sales, right, on the sales side, multifamily sales, well, people must be in trouble, right? People must be like giving away apartments. Guess again, cap rates have barely budged. And I know this for a fact because I'm in 2 escrows right now. And those cap rates, let me tell you, for turnkey properties have barely budged, which is very surprising, right? Given what's going on. I would say that turnkey properties definitely are staying on the market longer, that's for sure. Value add properties tend to go pretty quickly, and you'll get multiple offers on those. But even so, it's not like you can get a 6 cap. It's hard even to get a 5 cap, okay? And apologies for those who are not maybe as familiar with some of these terms, cap rates, gross rent multipliers. We actually are going to cover that next month. If you come to our meeting, we have a special meeting during a special time during the collective team meeting, and where we're going to talk about how to calculate cap rates, how to calculate gross rent multipliers, basically how to calculate value in a property. And I think that that's something that, surprises a lot of folks, is that cap rates have not really come down. And like I said, I personally, right now, I have a client in a 1031 exchange. They've got like 4 million cash, okay? And we are scouring, looking for good cap rates, and it is not easy to find, So that's been very, very eye-opening even for me, just to see what's going on in the market. Obviously, properties that don't have, how should we say, that where there's lack of collection, those are issues, and there may be opportunities there. Where there's real opportunity, right, I think everybody realizes this, is in the retail space, right? Real commercial properties, that is, those that have retail, hospitality, those guys are in trouble, for obvious reasons, because of the shutdowns, restaurants, hair salons, hotels, those types of properties, they're in trouble and they're not making their payments. And if people can figure out a way to repurpose those types of properties, there's opportunity there. But there's a catch. And that catch is that you have to find the financing for that, right? A lot of lenders are not going to finance a vacant or non-paying commercial property, right? So say you find a property and you like it, you may have to put more than 50% down, maybe 60, maybe 70% down. That's a lot of cash, okay? Whereas with multifamily, the one thing is, because there's 90% plus collection rates, lenders are still lending on multifamily. And what I'm seeing, the reason I think that cap rates have not gone down is because people don't have to sell. They may want to sell. But if they can't sell, like I've had clients do this, where they didn't get the cap rate that they wanted, they couldn't sell it for what they wanted. So they just took it off the market and they refinanced and cashed out. And when interest rates are in the 3% range, I mean, why wouldn't you consider that? right? It's definitely something to think about because interest rates are so low. And if you're still collecting rents, then why not do so, right? Something absolutely to consider. So that's kind of my market update for right now. We will get into more details, after our guest speaker speaks. We always have an opportunity for people to talk about their wants and needs, talk about any off-market opportunities that they might have. We've definitely had deals done in this room when we had a room. And so it's opportunity. If you have properties, you're looking to sell, you're looking to buy, we ourselves know of owners on our property management side that are willing to sell, that are not on the market. So depending on what you might be looking for. So we'll get to that after our guest speaker today. Eileen Kendall is our guest speaker, and Eileen has her own firm. She deals with all real estate matters, and I'm proud to say that she represents our company, our property management company, TR Properties, on several cases pending right now. So she is someone that we absolutely depend on, and really knows her stuff. She's great with clients, and highly recommend her. I will ask for all of you in the room, if let's hold our questions till the end. And then if you do have a question, let's try, how should we put this? Not to go too far down the rabbit hole of like, I have a tenant that, blah, 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 has a specific issues. Let's try to keep our questions so that they can apply to most folks, because I could spend here all day and ask specific tenant questions. But that's what a private consultation with Eileen is for, or a landlord tenant attorney in general. So with that, let me turn the floor over to Eileen.
Thank you, Will. Like you said, my name is Eileen Kendall. My firm is Kendall Law. I've been in practice of 17 years. I can't count anymore, but I've been in my own firm for a little over 4. And it's been a good time for our firm, even despite all of these rules and trying to understand them. So like you said, I specialize in real estate, and a part of that practice is dealing with landlord tenants. Where I used to represent both, I now just represent property owners and landlords. Very, very few tenants, just because of the conflict issues. I'd rather have you guys as landlords as clients than tenants as clients. So let me share my screen, and I have a PowerPoint to make it, because it's a lot of information, and a little overwhelming at times. So I try to do it in a slideshow so it makes a little bit more sense. So what we're going to talk about today is the extension of the COVID-19 Tenant Relief Act of 2020. So as we all know, in September, the Tenant Protection Act was placed 3088. That was to sunset at the end of January, and it had specific rules. Well, now because of that, there was this emergency order, which is now Senate Bill 91 instead of Assembly Bill. It's SB 91, and it is now scheduled to sunset in June of 2021. And what it also did is not only extended it, thankfully, it provided some clarification, because there were some, lots of conversations between landlord and tenant attorneys on what you could and couldn't do, because it was vague, and there was no real guidance. And one of the things they did is they did help us a little bit to give us a little bit more guidance. So will Senate Bill 91 apply to my property? Most likely, yes. The only exceptions are commercial, corporate renters. So if you're a company that rents your place out, or is renting something for an employee or something along those lines, that's going to apply. And hotel, motels, transient occupancy, those are really the very, very few exceptions to the rule. where most people remember when AB 1482 went in place, there are exceptions for single family condos, those types of things. Those exceptions don't apply. Those will be under SB 91. So the code section that it really did create or amend is 1179.03. One of the most important things you need to take out of here today is that you need to give notice to all non-paying tenants. Another informational notice, one should have been done in September, a new one that needs to be served by February 28th, 2021. Now, this new extension has specifically said that if you don't do that, you might be precluded from certain activities down the line, whether that is collecting rent in small claims or trying to terminate a tenancy or something. So please, if you only take one thing out of this meeting, take out that you need to give this extension notice to your tenants that have not paid. And I don't care if it's just 1 month, 3 months, 6 months, sporadically, give them the notice. And so what it's done is, you still have your March 2020 to August 2020 notice. I'm sure that most of you probably have at least one tenant that hasn't been paying, and you saw these notices. Their 3-day notices are no longer valid. You have to serve 15-day notices, and there's different ones. So there is one 15-day notice for rent for March 2020 through August 2020. There's one for other monetary. So if you have late fees or other charges associated during that time period that's not paid, you cannot include that in the rental one, just like you wouldn't be able to include that in a 3-day notice back in the day. You would need to send a separate one. Then there's the same form if your property is subject to the CARES Act. So if the property is got a federally backed mortgage or is Section 8 or something like that, you need to make sure that you're giving that notice because the time periods in that notice are different than just a standard 15-day notice. Prior to this extension, you had a form that was for non-payment of rent or costs or other charges. That was from September to January 1st. That form can no longer be used. Now you use this form at September 1, oh, that's a typo, September 1, 2020 to June 30th, 2021, when this new extension is set to sunset. The 15-day notices are about 4 or 5 pages long, and one thing you have to make sure that you're doing is you're including that declaration of financial hardship. Now, if you have non-payment rent of non-paying tenants, you might think, well, I don't want to do the notice, or I'll wait a little while until this sunsets. One of the benefits of the 15-day notice is that, and I probably talk about it in another slide, but here I go, out of order. But if they don't turn in that declaration, then you could proceed with an unlawful detainer. Now, the one thing that they have done is they've clarified now that if after the unlawful detainer is filed, they then come waiving the declaration and say, oh, I forgot. They have to go in front of the judge, and I watched one, the tenant has to, on a notice motion in front of the judge and other party, say why he didn't do it, and if it was by unexcusable neglect, or something like he was in hospital COVID, some extreme circumstances, the judge may not allow it, and you could continue with your eviction. The one I watched, I think judges are a little soft, but he had a sob story, and the judge threw out the case. But at least now that they can't just get the case dismissed. They have to show why they failed to do it on time. The 15 days, it doesn't include weekends or holidays, so it's really like 30 days. And what these notices do, and what makes it very different from a 3-day notice, is most of it is language with respect to what their rights are. The new notice and the informational notice that needs to be sent now includes what we'll talk about a little later, is the rental assistance that came about with this new extension. And again, like it was before this extension up through January 31st, the tenants, in order to be protected at the expiration of this, is that they have to pay 25% of the amount due that came due between September 1 and June 30th, 2021. Now, they don't have to make that payment monthly. All they have to do is make a 25% payment of the rent by June 30th, 2021. If they don't do that, even though they sign the declaration, you could still proceed with the termination because they didn't follow the rules. So what these notices do is it puts the burden and shifts the burden to the tenants to do something. Eviction actions, yes or no? So basically, the way it stands right now is a landlord cannot start any unlawful detainers until July 1st, 2021. And that's, like I said, if the tenant does not pay the 25% of rent by June 30th. Now, most of you probably have LA County properties. That rule doesn't apply. Because LA County is giving tenants up to 1 year to repay the rent, they have that extension of time to pay the rent. Something the legislation doesn't really think about, and LA County just keeps pushing through on these, is it really is in contradiction of it, and really makes it difficult to know, well, can I or can't I? So just on the safe side, if you have a tenant in LA County, they have 1 year to repay that rent. You wouldn't be able to terminate that tenancy until that year period has gone. Like I said, with the late declaration, the tenant can file that late declaration, and after a noticed hearing, and the judge deciding whether it was a result of a mistake, inadvertent, surprise, or excusable neglect, may allow it. But it's potential that if the guy the tenant just says something like totally random and the judge doesn't feel like it is, you could proceed with your eviction. When will courts enter judgment? So that's in an unlawful detainer. So if you brought an unlawful detainer and your notice was given prior to March 1st, 2020 and expired before March 1st, 2020. For instance, I had a case that was filed by another attorney in January, and then everything went on hold. The attorney didn't do much in way of getting the case moving. I got it, and we were able to settle it with a move out. So we didn't have to deal with trying to have a jury trial during this period of time. But because the notice was given in 2019, it expired. It was a 60-day notice that expired well before March 1st, and our case was filed before March 1st. We were able to push through. Again, if the tenant didn't submit a declaration, a judgment can be entered. And if the tenant, now I'm going to say these, but know that under LA County, the rules are different. If the tenancy terminated for any of the following: at fault, just cause, except for non-payment of rent. So a lot of the cases that I'm handling right now are that these at fault, just cause for other violations. Now, I had a call with a client that had a list of minor violations, and I told him, the penalties, I'm trying to help you avoid the penalties of trying to terminate a tenancy and then be subject to litigation based on your violation. So these are for severe violations. I have one right now where he had prostitutes coming in and out of the house, and there was an assault, and there's police reports. So I'm pushing through. To me, that's a major violation and a safety. So I would take a look at whatever your cause, whatever your grounds are, and let you know whether or not you could really push through without violating any of the rules. Under SB 91, there is allowed to be terminations for no fault, just cause, for everything but substantial remodel, unless it's related to health and safety. So under the state law, if you have properties in any county other than LA, this would apply. If you have, like I have one in Orange County that I was telling Will about before we got everybody on, where my client purchased a property to move in his elderly parents. When the time came, the tenant had a year lease. They gave a notice of non-renewal because they want to move the family, the parents in, and now they're not moving out, and they have attorneys, and it's just crazy to me. But that is just cause, is to have moving in a parent or a child. However, in LA, you need to check that because in LA, right now, you cannot have no fault, just cause terminations. There has to be cause. So kind of going through what the 1482 at fault just cause, which would fall under the umbrella of SB 91, is a breach of a material term, like we talked about. But the new law requires, not the new law, but even AB 1482, is you have to give notice before you give notice. So you used to do a 3-day notice to cure or quit. That under the law is not sufficient. You have to give some other kind of notice. I don't necessarily think it needs to be a formal notice. What I tell my clients is to go ahead and just draft a letter that says, hey, you're in violation of the lease provisions XYZ because you're doing ABC. You have 10 days to cure it. And then when they don't cure, then you can serve the 3-day. The law says that you can do a 3-day quit, but I'm always on the safe side and I do a 3-day cure quit, because if they didn't cure it in 15 days, they're not going to cure it in 3. Nuisance, criminal activity, or using the property for unlawful purpose. That I'm seeing a lot. However, in LA County, you cannot terminate a tenancy related to nuisance or extra tenants or pets if those things are because of COVID-19. So if somebody has extra tenants because, or extra occupants because they had to move in somebody that they're taking care of, you can't terminate that tenancy. The nuisance ones to me is weird because, you know, I think you should be able to terminate it, you know, even if you had somebody. I don't know how a nuisance would be COVID-19 related, but you have to, again, be careful of your local rules on what they prohibit. And committing waste, that's basically damaging the property. So if the tenant is got material damage to a property, you can terminate. I have one in that is, it's a 2 on a lot, so it would be subject to, you know, 1482, but their own negligence started a fire in the dryer. The house is substantially damaged and there's no roof. They refuse to move out. They want us just to go do the repairs while they're there. I'm set to go on a jury trial on that on March 1st. So we'll see what happens. I'm going to get the insurance adjuster because their position is that, oh, well, we understand that you want to spruce up the place while you're doing this. And that's why you want them out. That's not the case. The pictures of the damage is really significant, and that's committing waste, plus the piles of junk in the front yard. So if a lease ended after 1/1/20, failure to renew after written request from the owner. So if you have an expiration of lease, and some people like to get new written lease agreements, if they refuse to do so when the terms are substantially the same, that is an at-fault just cause. And it is that way under, so you also have rent control rules, right? It's under the municipal code that you can also have that as just cause. Now, refusal to allow entries for repairs or other authorized persons, that is not allowed right now under LA County. You know, if you're showing properties for sale, you also can't do that under the health orders. This was a big change from 3088 to now, is that, and also it was in the extension of LA's county moratorium that wasn't in there before. So when they extended it this time, you can't terminate if they don't allow you, unless it is something that is extremely to the health and safety. So if there is some habitability issue that's going to cause severe damage to a tenant, they do really need to allow you to make the repairs. Employees' failure to vacate after employment has been terminated. That is still a valid just cause. And failure to vacate after providing the owner written notice of intent to vacate. So this would be I like to get tenants into this where we're discussing resolution and then they'll say, okay, well, I agree and I'll move out by March 31st. And then if they don't move out by March 31st, I can file my eviction because they said that they were going to move out. I'm sure there's some like loophole, but that's what I would try to do. Under 1482, which has been encompassed in SB 91, again, the caveat is to check your local rules because LA County has more restrictions because you can't really do these in LA County. But the owner move-in is allowed. But I am finding, and this is another thing, I guess, the two things I would want you to take out of this. When 1482 passed, you were supposed to give notices to addendums, whether it was part of the lease when you got a new lease or an addendum about the 1482 exclusions. And one of those provisions is that the tenant agrees that the landlord can terminate the tenancy to move a family in. So what right now is a just cause in anywhere but LA County is if the owner needs to move in or move a family member in, it's allowed, but you have to have had given that lease addendum notice. And I'm finding that that's not being done. So, you know, it's going to be a hard push, even if you wanted to try it, which I have in settled cases and it works, but then I have ones that don't work. Withdrawal from the rental market is not allowed in Los Angeles County, but is allowed from SB 91. Now, if you have a single family that is for rent and you did give those proper exempt notices, kind of like the one for the owner move-in, and the property is in contract for sale and the buyer intends to occupy the unit, you can terminate the tenancy for that ground. Compliance with order relating to habitability. So that's your substantial remodel that we talked about a little earlier, is that you have to be, you know, something that, you know, maybe it's red tagged by the county or there's, you know, something going on, then they don't allow you to, then you can't do those repairs with them in the property. That would be a ground. And as we talked about a little bit earlier, is the tenancy terminated before March 1st and the notice expired before March 1st, then you can proceed with the eviction. And I think that's a lot of people may have been giving notices right at the beginning of the year. And then as the court shut down from, you know, from March to sometime in May, nothing was happening. And then when the court started up, some people might not have gotten the process going. So I have a few of those older cases. Just to recap on what if the owner is selling and the buyer wants to move in, you needed to give that exception form to them prior. And so here was what I would say is if you have some of these single family properties or condos that are being rented, go give that addendum. I suppose that you couldn't now proceed on this, but if there are rules coming down the pipeline, at least then you've given that addendum and they're acknowledging it and you have it. Because these laws are changing, they're evolving, they're getting stricter, they're requiring certain things before you can take action, that you may want to consult with somebody, whether it's my office or somebody else that does landlord tenant work, to go over your leases. Make sure your leases have all the right addendums. Make sure they're all in compliance with AB 1482, because those even are for multifamily. I think the addendums needed to be given to everybody because it lays out the just cause, what's exempt from just cause, but it's also the rent caps. All of that stuff that was in place with the Tenant Protection Act. Please don't resort to self-help. You might laugh at that, but I get calls. Can I turn off the utilities? No. Can I turn off the cable? Well, maybe. You cannot lock them out. You cannot turn off utilities, and you can't harass them. And that includes any actions that could be construed as, you know, harassing them in a way that would make them leave because they don't want to deal with you anymore. Landlords and property managers can subject to damages of at least 1,000, but more than 25. And I think that that's per violation. So if you continue to do things, you could be subject to some penalties. But I'm also seeing these tenant attorneys are really bored and they're circling like sharks, and they are filing affirmative actions against landlords in civil court, asking for hundreds of thousands of dollars in damage. And if any of you have ever been through civil court, it's not anything fast. Well, not that eviction court's really fast right now, but it's slow and it's costly. So not only could you be subject to the civil, statutory penalties, you might be forced to in litigation. And I have one that's not even close to trial. My client's already spent over 15 grand. So you want to try to avoid that. So don't harass them. Don't turn off utilities. Interesting, with the extension, they have now said, and I don't know if this was happening before, and that's why they did it, you cannot sell COVID-19, oh no, I'm sorry, this one is, you can't use the alleged COVID-19 debt for a negative factor for the purpose of valuing of prospective housing. So if you have a tenant that vacates and the next owner calls you for a reference, you can't use their non-payment during this COVID-19 time as a negative factor. And then you as owners and property managers can't use that as a determining factor for renting. And then that's where I was starting, is you can't assign or sell unpaid COVID-19 rental debt. They used to bundle all those securitized loans, or those loans back in the 2008, 2011, 12, to securitize trusts and bundle them all together and sold them to investors. You can't do that with COVID-19 debt. Right now, you cannot increase rent, decrease services, or cause a lease to quit, a tenant to quit involuntarily, or bring an action to recover possession or threaten to do any of those things to retaliate. So, this is a fine line that I am really playing, because I really feel bad for all these landlords and these property managers. Is there another way to get them out? So they're not paying rent. What else are they doing wrong? And like I said, the one client gave me a laundry list of things, but it wasn't significant enough, because there is this, if it's on them, they have the burden of showing that this was done as retaliation for them not paying rent. And that's going to be a heavy burden, because if you really severely have these, lease violations that are documented and substantial enough, they might not be able to show and prove that you retaliated. And again, there are punitive damages associated with these acts. If you filed an eviction case and they did prove that you were in fact retaliating because they didn't pay rent, again, there are those punitive damages, no less than 100 and no more than 2,000 for each act. And they can be awarded attorney's fees. So if a tenant does serve the declaration, obviously you can't try to evict for non-payment of rent, but you cannot charge or try to collect late fees. You can't increase fees charged to a tenant or charge a tenant for services that you used to not charge for. These things I'm going to push into that category we just talked about as doing acts to retaliate and try to harass them out. However, if you take away an amenity, like say the swimming pool, because the county said you had to shut down the pool or the clubhouse or whatever it is, that is not a penalty, because you're complying with a court order. So what happens when they do the COVID-19 declaration? You can never terminate, and they pay the 25%. You can never terminate their tenancy for non-payment of rent for those time periods. So you're done. But you can bring a breach of contract claim in small claims, and they have extended the amount of claims that you can file in small claims in light of this. And they also extended the dollar amount. It used to be capped at 5,000 or 10,000, but those are now extended. So if you have to bring although I have to say, you know, it depends on what it is, because I can see that some people are going to be, you know, $50,000, $60,000, $70,000 in arrears at some point in time, that might bump up out of small claims. They're also now capping attorney's fees in eviction cases, and it's determined by if it's uncontested. So that means the tenant didn't respond and I get a default judgment. If it's contested where it's very minimal and it's a court trial, versus looking at one where they request a jury trial and there's lots of discovery and there's lots of motions, they're going to look at that and cap them. And it's a pretty small cap, which is unfortunate because jury trials can cost anywhere from $10,000 to $15,000 at a minimum. Because of the nature of a jury trial. So the last topic I'm going to talk about is the biggest change is in SB 91 is they're providing rental assistance. So they're saying to these landlords, you can't collect rent, but now they say, we have something for you. There's $1.4 billion of federal COVID-19 emergency rental assistance that's going to be allocated to the state rental assistance program. Local governments are also thinking and figuring out how to get $1.2 billion in additional funds for their own rental assistance. So you might have state rental assistance and your federal. They are going to be administrated by this Department of Housing and Community Development. And I think I mentioned it a little later in the slides, is that they have systems in place so there's no double dipping. I don't know how they're going to do that, but you can't apply for the same property and get relief from federal and get relief from state. So the big question I've been getting, because I sent out a news blast about this a couple days ago, is who's eligible and how do I get it? To be eligible to receive rental assistance, the household that is delinquent in rent must meet all of the following. At least one person is either qualifies for unemployment or has experienced a reduction in household income or incurred significant expenses due to COVID-19. So I'm going to assume that's going to fall in all the categories, because that's why they're not paying rent, unless they're, you know, just trying to work the system, which a lot are. At least one person in the household can demonstrate a risk of experiencing homelessness or housing instability, which may include an eviction notice, past due utilities, unsafe or unhealthy living conditions, or any other evidence that the department that is going to administrate this feels is going to fall into that experiencing homelessness. Because a lot of people are in units that didn't adjust the rent every year, or, you know, so under market that these tenants can't afford to find a new place at market rate. So I think the department's probably going to look at that factor. So if you have a tenant that's paying $900 for something that's going to be, you know, $1,500 at the, you know, market rate, they're going to have a problem because they obviously can't pay the $900. And the household income has to be at or below 80% of the area median as determined by the Department of Housing and Urban Development. So those are the requirements, but just because a household is eligible doesn't guarantee that they'll be awarded rental assistance. Funds are going to be prioritized first to eligible households with a household income less than 50% of the median. In Los Angeles County, the median income is $77,300. So to get first in line from this rental assistance, the household has to make less than that. Orange County is $103,000. So to be eligible in Orange County, you'd have to make 50% of that. Not eligible. But that's where the first pot of money is going to go. They're going to prioritize and give money to these people first. Then they're going to distribute to communities disproportionately impacted by COVID-19 as determined by the department. So I think, you know, while we all talk about fair housing, et cetera, I think that they're alluding to the fact that, say, Hispanic families or Black families or communities are suffering more significantly from COVID than say a affluent neighborhood. I can only assume that that's what they mean, even though to me that seems like violations of fair housing all over the place, that they'll be the next pot. And finally, all the other eligible households with a household income less than 80% of the area median income. So they're going to divvy it up in that order. Now, the landlord and the tenant kind of need to work together to do this. But a landlord can apply for rental assistance on behalf of the tenant if the tenant doesn't want to do it. But again, you will need the residents' cooperation because it's based on their income. It's based on their demographics or whatever it may be. So they need to work with you. Eligible households may receive up to 80% of their unpaid rental debt accumulated from April 1 to March 31st. Now, the caveat to that is, oh, I guess that was my last slide. The caveat to that is that a landlord has to agree to give up the remaining amount of the rent. So if they don't give up the remaining 20%, then they may be able to get up to 25% of the arrears, but you're probably not going to get any because it's going to be applying to all those other people. I think I'd rather have 80% of the rent than none. So I would say that it's probably a good idea to give up the 20% and get what you can on payment on those from that rental assistance. The application process has not been determined yet. We've been told that from the sources that I look at, I use the California Apartment Association. I'm a member of it, and that's where I get my forms and where I get my updates. That by March 15th, they should have something out that's going to demonstrate where you go, how to apply, what to do. So I don't have answers to those questions yet, even though I have people asking. So that's kind of SB 91 in a nutshell. It's a lot of information. There's lots of nuances, but you definitely have to make sure that you're looking at your local rules, because the local rules are more prohibitive. It's too much to do all in once. So I wanted to kind of focus just on this new passage. For LA County, every month they're re-looking at it. So right now the prohibitions are set to expire February 28th, but I'm going to guess in about 2 weeks, they're going to tell us it's March 31st. So that's it.
Thank you, Eileen. So we're gonna do a little Q&A right now. So if you do have a question, we'd ask you to raise your hand. If you don't know how to raise your hand on Zoom, it's under reactions with the little smiley face with the plus sign, and there's a little raise your hand icon there. But I'm going to start the questioning. There was a question in the chat. That question is, and there's clapping. From clapping icon from somebody. So question, do these eviction rules apply to commercial tenants as well?
No, SB 91 is residential only. However, LA County does have their own commercial prohibitions, but they're very limited compared to the residential. But that's for another day.
Okay.
All these topics could go into days of talking.
Got it. I have a question from Ray. What can be done if a tenant's lease expires and you don't want to renew it? And this is in Riverside County.
I'm not sure about Riverside County. I think that it's going to fall into everywhere else because I think SB 91 clarified that. This is one of the biggest issues I was facing, is that there wasn't any clarification on this, is that you can't. The issue I have with that is that if you have a year lease and it expires and you don't want to renew it and they are paying rent, if you accept the next month's rent, you're now creating a month-to-month tenancy, and then you're in a whole new world. So I'm advising my clients, if you're in that situation with a tenant that is paying rent, is if you're taking that rent, do it under reservation that you are not extending, and you just need to make sure you're documenting that with the tenant, that you are taking this under reservation and you are not waiving any right to terminate the lease per the original lease when these prohibitions are over.
So you suggest you can take the rent, like, because we, in previous times, we were told, like, if we had, say, a non-rent controlled property and we didn't accept the rent or didn't accept it past a 3-day note, like we were told not to accept it specifically past a 3-day notice, but you're saying you can actually accept
No,
the-
so that's different. So on a 3-day notice, they have to tender the payment within, and there's no more 3-day notice. So that 15-day notice, if they tender the rent within that 15 days, you have to take it because
Right.
that's what the requirement is. A landlord can choose, if you've started the eviction process, that after that period of time is expired, you can not take that rent. You
and
can
move forward
reject
with
it.
the eviction.
But if you take it, you're waiving your right to the eviction.
Right.
What I'm saying is, if you have, like, if you're using a standard California Association of Realtors lease, it says the term expires at midnight at this date, and it would be subject to becoming a month-to-month, either by writing or by local rules.
Right.
Well, if you accept rent from a tenant, that then creates a month-to-month tenancy, and you can't terminate anymore based on the expiration of lease. Now you have to have just cause.
Right.
It's a gray area. You know, I would say, you know, not taking rent, sure, and then you're not creating that. But if we're in this environment for a year and you didn't collect that rent, there you are. If you take it with reservation and without waiving your right to terminate, and with a, you know, a letter or something back to them just saying, we're accepting this, but we're taking it under reservation. We're not waiving any rights to terminate under the lease when these prohibitions are done. That's what I was talking about.
Got it. So a letter to the tenant stating that you're accepting it under reservation.
Yeah.
Is what you're suggesting. Okay. A question from Ted, and I think we can, any specifics regarding City of LA rent stabilization properties? We have month-to-month tenants whose leases based on the rental leases have long expired.
Yeah, so you have month-to-month. Really, the distinction in the LA County moratoriums is that under rent stabilization ordinance right now, you can't raise the rent. That's really the only exception, because LA County's rules are so extremely prohibitive that it falls right in line with the LARSO. And the only difference is that on non-rent control units, you can raise the rent, but you can't on those.
Right. Okay. Armin has a specific question about, do you handle commercial tenant eviction? I assume yes.
Yes, I prefer those.
A lot easier.
Yes, but it also turns in, the other reason I like them is because then it can turn into a breach of contract civil case, because if there is a term left, you can then bring a civil case for the rest of the term of the lease. So that gets me into my civil litigation world.
There we go.
The
Tina asks, if the AB 1482 notice was not given to tenants previously by the deadline date in the LA County, can it be provided to tenants now?
I would. Whether that's going to fall in line to something down the line, I don't know, but I certainly would. That's kind of why I said it. If you have leases that you're not sure, it's probably a good idea to, you know, especially we're in the first, you know, part of the year, to go through and make sure all your leases are in order. Even if you're on month to month, you could get them into a new lease on similar terms. So your lease would be month to month at the same rent, but you're going to include the right language. You're going to have the right addendums, and they don't sign it. It's just cause for termination when we get through COVID.
Okay. Okay.
But I would definitely look and make sure that you're doing those, because I'm sure at some point some other rules are going to come into play with that.
Right. Diana is asking, what happens if you have a tenant in LA City rent control who was paying the 25%, but has stopped doing so? Is there anything a landlord can do?
No, so they don't have to pay 25% every month. If they did the financial hardship declaration, all it says is they have to pay 25% by June 30th. So they can pay it all at once by June 30th. They don't have to be paying it month to month. it's nice that they were, but maybe something changed and now they can't. But yes, or no, there's nothing you can do. You have to wait till June 30th.
Got it. A question from Laura. If a tenant is paying half of the rent due, should they get the form? Where do I obtain the forms?
Yes. I get my forms from California Association of Apartment Association. I'm sure there's lots of forms out there. I think I know Laura, but the name sounds familiar.
Yes,
but
you do.
I could certainly get those forms for you. I have them in my little resources, but you know, there's probably tons out there if you Google it.
Yeah,
and I'm sure that Greater LA has them too.
We're in the Apartment Association of Greater Los Angeles. They have forms as well. I also included in the chat at the very beginning the state of California website for landlord and tenant resources. That's landlordtenant.dre.ca.gov. So you guys can all use that as well. So there's a number of forms on there as well.
Yeah, but just to confirm, yes, if they're not paying the full amount of rent, you want to do the notices.
Okay. Can you please both share your contact information with us? Yes, we'll put that at the end. Meza or Miza, apologize for the mispronunciation. We are in escrow in a 2-unit home with Section 8 tenants, I'm assuming. The buyer wants to live in the unit. What is the rule with Section 8?
Good question. I would have to look that up. I think that that's not going to be relevant right now with respect to you can't terminate the tenancies under the general rules. Section 8 usually requires, instead of 60 days, it requires 90-day notice to terminate, but you can't terminate unless you have cause right now anyway. And if it's a multi-unit, it doesn't fall within that exception that I talked about for owner-occupy.
It's only for single family. Mm-hmm. That's interesting. Okay. Make that mental note, guys. Very important. Very important. MY asks, is it also prohibited to raise rent by 3% under the city of LA rent controlled units? That answer is yes. It is prohibited to raise rent right now.
Yes.
It's 0%.
Yes.
Not 3, 0.
Yeah. Yeah, under rent control right now, you can't raise rent.
Yep. Okay. Where can we get more information on commercial tenant evictions?
Well, I think he's asking is when. So when do you want to have me come back?
When can we get? Good catch.
You can have me come back and I can talk about commercial tenant evictions and whatever they are.
Well, you're one of our most popular speakers. I have a feeling you're going to be coming back.
Yeah. Or you can call my office and set up a consultation. I do half-hour consultations. It's $210 for the half an hour, and I can answer any specific questions that you have with specific tenants.
Right. Okay. From Amber. You mentioned one person in the household must prove hardship. What if that person is not on the original lease? Also, would this constitute just cause for eviction, moving in other tenants, pets not on the lease? It is not COVID related.
I would say if they're in the household, that's probably going to count. You want to get the assistance, right? You want to get those rents paid. So I would say that if that's somebody that is living there and can show that they're on a utility bill or somewhere, mind you, it's probably an illegal sublet or whatever it could be, that's a whole nother ball of wax. That as long as that person shows that there hasn't been any specific language or clarification on that about applying, if it's not named on the lease, it didn't make it seem like that was a requirement because it wasn't mentioned. And so it's unclear about the extra tenants. It says related to COVID. So to me, the way the statute reads and what I look at, that means if it's not related to COVID, then you can terminate for those unauthorized occupants. Then they're going to just say it's all COVID-19 related.
Right, which is the problem we're facing, right? We've got some issues with that as well, where people just claim COVID, even if they're not COVID related. I have a question, and I think, other people may have this as well. Say you have a tenant who's not paying, but they have a co-signer on the lease. Is there anything you can do in that scenario?
Yeah, so I had one that I think came a referral from you, maybe not, but where the co-signer was out of state. The co-signer didn't live here. They knew that there was money, and I sent a nasty letter, and the rent got paid. So the guarantor paid the rent. Now, a lot of other stuff came up after that with other things that are, I'm not handling a case anymore, but then the tenants like to complain about everything and anything, but the guarantor paid the rent. So I think that when you're serving the 15-day notices, if you have a guarantor or a co-signer, even if they don't live there, you're going to make sure that you're giving notice to that person, because that person's credit is on the line and they might not be suffering from financial hardship and they might just pay it.
Right. Very good point. Very good point. Do we have any other questions for Eileen?
Yeah, one just came up from Ray.
Oh, okay, Ray, here we go. If a tenant has a police report for something that has happened on your property, it seems there are privacy laws, so as the owner, you can't get a copy, even find out about it. I was able to get a call report, which did not include the police report.
Yeah, I'm finding that you're not able to get that information very readily. What I've been doing in my notices is, you obviously have the details. On X date at such time, this happened, the police came, a report was made, get an officer's name if you can get at least that information. Because even I think under LARSO, that's sufficient in their general ordinances, that if you have those details and can show that. Because yeah, I try to get my clients to get those police reports, but they don't seem to be able to.
Got it. Question from Brad. I have tenants in a 1-bedroom unit. The tenants have built a dividing wall to use the living room as a bedroom. Can I require them to take it down?
Well, that's not related to this, but I would say that that's a lease violation. They've modified, because most of your leases have all that language that you're not supposed to paint, you're not supposed to do X, Y, and Z. Yeah, not likely that they'll do it, but you can ask them. But that could, and again, it's so weird because you just never know what a judge is going to feel as something as a material breach. Maybe a judge looks at that and says, who cares? It's not a material breach. Where you might have a judge that says, that's a material breach, you're out.
So it's depends on what mood the judge is in, or if they ate lunch. I found that like previous to lunch, they tend to say no. After lunch, they tend to say yes.
Yeah, right. Yeah. So, you don't know until you try it.
Right. But then you have to take on the costs of it, and the attorneys.
But it never hurts to give give a letter first. Hey,
Yep.
Mr. Tenant, I see that you have put up a wall where you weren't supposed to. Please look at least paragraph whatever. You're not supposed to do that. Please remove it.
Enough. If you do want to take someone to court right now, what is your estimate as to how long we can expect to have our case be heard or decided, given that we are in a pandemic and there's a backlog? Gosh,
so as Will knows,
I know a lot
if it's in Pasadena, they're not even setting trials. So in Pasadena, they are still setting trials that were asked for in December. Now, in other cases, I've been appearing. I have appeared for trials, several in the last couple of weeks. What the judges are telling us, and obviously I haven't gone out on one yet because the tenant always has some excuse or something, is the judge is saying that it's really hard to pull a jury. So if there's a jury trial, that's where you're going to run into more delays because they can't get enough people to become to juries. Court trials, I think the judges are doing them. I mean, I schlepped down to Long Beach with my notebooks and had a mandatory or a involuntary settlement conference because the judge wanted to get the case settled. And, it seemed silly that it wasn't because it was a commercial property and he had 2 of them and it was just ridiculous. And we got settled. So it really depends on where your case is and how backlogged they are. I'll tell you, Pasadena, in the fall.
I hope not.
Long Beach and Compton.
My
So far, Long Beach and Compton's moving along smoothly on cases that I've not filed too long ago. I have one in downtown. He seems like he's sending them out to other departments. So it just really depends.
It depends where this Amber said in LA County, but it depends where in LA County.
Yeah,
your case.
You'd be sent out to certain hubs, and depending on that hub, we're learning.
Ted asks, if an LA County inspector says that repairs are needed to be made based on unauthorized modifications made by the tenant, can we charge the tenants for the repairs?
I'm reading it just because I want to understand it. So the tenants, is it the tenants that made the unauthorized modification? Yes.
That's what
So the tenant made the unauthorized, and the city, yeah, why not? You're not going to get it.
Right? Yeah, that's the problem. That's the problem. Enforcement.
Mhm.
LOL.
You know, and that's the thing, you know, one of the problems I have with the legislation, and I understand they want to give these landlords the right to go and collect that money, but you have a tenant that's done the declaration, you can't terminate for tenancy or for possession because they did what they were supposed to do, and you're going to go take them to small claims court to go collect that back due rent. You get a judgment for $40,000. What are you going to do to collect it? You're going to garnish their wages or their bank account, and then they can't pay rent, and then you got a whole nother, you know, it doesn't make sense to me. You're going to have a judgment that if you try to collect, you're going to, yeah, you'll get them out for possession, but how's a jury going to look at that? That's how I look at most cases when I start them, is what's the jury's perception? Because the tenants want to punish landlords and ask for jury trials. It's extortion in hopes that you'll just go, here's some cash, go away.
Yeah, that's
because it's expensive and timely.
To that. Can we increase a security deposit to match the current rent in an LA rent controlled unit?
I'm going to say no, not right now. I don't know for sure, but just based on the restrictions that you already have in LA rent controlled units, I'm going to say probably not.
Okay.
And you can't, if I remember correctly, you can't use security deposits to pay back rent, COVID rent.
No, right? They're not supposed to. No, not at all. Although people try. Trust me, we've gotten many of those. I'll just use my security deposit for last month's rent. No.
Yeah, but I have some landlords that just want to do it anyway without the tenant saying anything.
Yeah, that's no. I mean, we obviously, as a property manager, we obviously not just discourage that, we just say no, you know, because obviously a security deposit is for if there's damage to the unit and you need that for the unit. So if you use it for last month, you have nothing left.
Yes.
No.
And then they could just trash your place and then you don't have any money.
Yes. Yes.
Yes, that is correct, Ted.
Basically tenant rights and no landlord rights.
It's pretty sad.
Okay. This is what I would say to that. I always say it's always important to, because obviously as property managers, we're kind of in between, right? We're dealing with tenants and we're dealing with landlords. It's important to educate everybody, all sides you're dealing with. And I think one of the reasons we do have fairly low delinquency rates is because we have stayed on top of all these rules, right? Made sure people realize what their actual rights are. And for a lot of our tenants, what we would do is, you know, just send them a monthly reminder. Oh, your debt is now X. Your debt is now Y. That's not harassment.
No, it's just notifications.
That's
right.
Notification that your debt is now $10,000+ Your debt is now $15,000+. Do you really want to like continue that debt? That's your call, right? But I think
it's important for everybody, you know, everybody's not in the same situation, and you got to think some of these rental units in, you know, the lower end of the spectrum, you know, they're not working. I'm sure they would pay the rent if they could. And so I tell, you know, just have some compassion and just work with them, you know. Obviously it sucks and it's not ideal, but you don't want to be a jerk. And again, I'm always looking at the perception of what a jury will look at.
Exactly. Given what's going on right now, like you have to be smart about how you're going to handle any particular situation. And is it worth going through the trouble of going through court and whatnot? You can ask for certain things, but you know, the question at the end of the day is what Eileen said. Will a jury agree, especially given what's going on right now?
Yeah.
One more question from Amber. Where should we go to educate ourselves on the changing rules the new notices required, etc. Any websites you are using, Will, that are helpful.
So, Will, you said already that you use the Greater LA, and I'm affiliate there. I have a banner ad now, so maybe you see it when you go there. I don't know how often it pops up, but I don't pay to be a member. So I get a lot of resources from there, but I paid for a membership, so I have access to everything on the California Apartment Association, because then it's a broader range. Not that I go out of the county too often, but at least that way. That's where I get it.
Yep.
And then also the LA County page has one.
Yeah, I just put, I think it's, and correct me, I know my team is on here. I hope I put the right website on there, agla.com. So that stands for Apartment Association for Greater Los Angeles. We are members of that organization. And Eileen just put down the county website. Those are good websites. Obviously, you attending this, agla.org. Thank you, Diana, for correcting me. And the California, Apartment Association is a great apartment association. There's lots of different apartment associations. If you have one in your local area, you may want to consider joining it, because it's basically a landlord association and a chance for you to get specific forms to your area. And every city has their own rules.
I would say if you're Googling it, be careful of taking forms off of attorneys' websites. Not all attorneys are good. I thought about putting forms on my website, but I didn't, I wasn't comfortable with that. But a lot of attorneys have free forms, but I don't know when they update them, how often they update them. So you really want to look to some of these organizations and not just off of some random search off of Google.
Because these organizations have their own lawyers on staff who review all of these to make sure that they apply. Because as Eileen said, you pull a form from somebody's website and it doesn't have the right verbiage, and you go to court with that form, it may not work.
Yep.
So you just want to make sure you're speaking to a professional like Eileen, or find a good property manager in your area, that has the resources to use. Diana also just put up the LA Housing and Community website. That's the LA Housing Department. Well, thank you, Eileen, for your fountain, your wealth of information.
I don't know how I keep it all in my brain.
You're always one of our most popular speakers, and there's a reason for it.
Well, I'm glad. I really appreciate you allowing me to talk to your group. And if you want to hear about commercial evictions, reach out to Maria and we can set up another one.
Yeah, absolutely. We can do that. That's definitely something I have, questions about as well. For those of you, as we're getting, we've run over for a while. So, if you guys have any questions, we'll put our contact information here. I'll put mine in right now. And Eileen, if you could put yours. And one question a lot of people have asked of me, that's not supposed to be a comma during the comm. A lot of people have been asking me as well about how our tenant in common sale is going. A lot of you who have been on these calls know that we converted an 8-unit apartment complex into a tenant in common property, meaning we were selling each of the individual units. And we used the Ellis Act in order to relocate or evict the tenants. And we are at a point where we have sold 50%. We're in escrow on 50% of the units. And all of our units have had multiple offers above asking. So if you're interested in tenant and common conversions and how to go through that process, please reach out. We're happy to take you through how we did it and what's going on with that. It's definitely becoming a very hot area that a lot of people have a lot of questions and interest on. And so with that, Kendall, Eileen has put her information, kendalllaw.net.
And that link is a digital business card that you should be able just to clip and take it, and has all my contact information.
There we go. I'll put our website as well. So people have it. And on behalf of the Collective Realty, and TR Properties and everybody, we thank you all for joining us. Like I said, next month, we're going to do a special session. This one will actually be, let me just check. It's going to be like mid-March. Sorry, just pulling it up. I just want to get the date right. I know it's on a Wednesday, and I know that it's going to be during the day, meaning like 11 a.m.
I think it's the 17th, Will.
The 17th. Thank you, Marshall. So that's Wednesday, March 17th at 11 a.m. We're going to do a special session specifically on how to analyze, a real estate deal, how to calculate cap rates, how to calculate gross rent multiplier, what those look like in different areas of Los Angeles and Southern California and throughout the country. So let us know. Thank you all for joining. Please reach out to Eileen if you have any specific questions on any landlord tenant or any real estate issues that you're dealing with. And feel free to reach out to us if you have any questions on property management, commercial real estate, or any other area that we can help. All right.
Thanks.
Thank you very much.